I'm attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is a continuation in a multi-part lawcast discussing OTC markets and in particular the different quotation levels and listing criteria for each level. In this series of lawcasts, I have spoken about the OTC QB marketplace and quotation criteria. Today, I will continue that discussion. The regulations that issuers must adhere to in order to trade on the OTC are numerous and technical. Consequently, an experienced OTC market attorney is essential in satisfying all OTC market listing requirements. As always, details determine diligence in maintaining a quotation level and meeting compliance requirements. Today, I am discussing the ongoing reporting requirements for the OTC QB. U.S. companies must maintain current in their reporting requirements with the SEC. Foreign companies that are not SEC reporting must remain current and fully compliant in their obligations under Exchange Act Rule 12G 3-2B, which means they must post in English on the OTC markets all information required to be publicly available pursuant to Rule 12G 3-2B. Banks must remain current in their banking reporting requirements. All OTC markets posting and reports must be timely filed within 45 days of the end of a quarter or 90 days from the end of a fiscal year for U.S. issuers, and for international issuers, they must be filed as soon as practicable, but in no event later than 6 months from the end of their fiscal year. Where applicable, a company must file a notice of late filing to receive a 5-day extension on a quarterly report or a 15-day extension on an annual report. All OTC QB companies will be required to post annual certifications on the OTC Markets website. All companies are required to comply with all federal, state, and international securities laws and must cooperate with all securities regulatory agencies. All companies must pay the annual fee. All companies must respond to OTC markets inquiries and requests. All companies must maintain an updated company profile on the OTC markets website and must submit an updated company profile form at least once every 6 months. All companies must file an interim disclosure in the event that company undergoes a reverse merger or change of control and make new updated certifications and disclosure related to the new business and new control persons. All OTC QB companies must meet the minimum bid price of a penny a share for at least the prior 30 consecutive, or at least one day in the prior 30 consecutive calendar days, subject to a 180-day grace period. Finally, all companies must use an SEC registered transfer agent and authorize that transfer agent to provide information to OTC markets about the company's securities, including shares authorized, shares issued and outstanding, and a share issuance history. Officers and directors of the company are directly responsible for compliance with the ongoing requirements. Entities that do not meet the requirements will be downgraded to OTC Pink. In the next lawcast in this series, I will begin my discussion of the OTC Pink marketplace. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are encouraged.